Hello and welcome to Special Session. I'm your host, Brian Schott. This is the show that breaks down the most important Utah political news and helps you understand what happened, how we got here, and just what it all means going forward. We don't have lobbyists on the show or anybody who's got a dog in the fight in any of these stories that we talk about. It's just straight news and analysis, just the information you need. And today on the show, we're going to be talking more about the gerrymandering case that is moving forward. The clock is ticking on the legislature's deadline to draw new maps. They have until about a week and a half from now as we record this to submit a new map to the court that complies with the guidelines in Proposition 4. So let's start with the latest news, and that happened on Monday when the Utah Supreme Court turned away the legislature's request for an emergency stay. They wanted to keep the old maps, the maps that were passed in 2021 in place, the congressional maps. If you remember, last month in August, the judge, Diana Gibson in the case, ruled that the legislature improperly overturned Proposition 4. They improperly repealed it. And so she said the congressional maps that they approved in 2021 were illegal and they couldn't be used. So what the legislature did is they asked her to put this on hold while they appealed the case, which would have kept the old maps in place. And she said, no, I'm not going to do that because the old maps are illegal, so why would we keep them in place? So they went to the Utah Supreme Court with an emergency appeal. They asked the Supreme Court to put an emergency stay on this, to keep those old maps in place. And on Monday, the Supreme Court, in a unanimous decision, it was unsigned, it's called a per curiam decision, it was unsigned, and they denied that request for an emergency stay. Now, lawmakers in this case, what they had done is they had agreed to the timeline to redraw the maps. That's what they mean when they talk about the remedial process. The remedial process is draw new maps before this deadline. You have the opportunity to submit new maps before the court steps in. They hoped that the court would stop the process. So they agreed to this remediation, this remedial move of drawing new maps, but they wanted to keep the current map in place. The district court denied that, so they went to the Utah Supreme Court. And in their argument to the Supreme Court for this emergency stay, they focused on the process. They were complaining about the process that the judge had imposed, having to draw new maps, but they didn't ask the court to stop that process. Instead, they argued that denying this stay was illegal, that the court overstep their authority by not imposing this stay, by declining their stay, by denying their request. And the Supreme Court didn't buy that. And in their arguments, what the legislature had said in asking for this stay is that the timeline for drawing new maps was so short. Remember, it was less than 30 days when the judge made her ruling, or just around 30 days. They said that the timeline was so short that they couldn't possibly meet all of the requirements under Prop 4, but that's not what the court said. They didn't have to fully comply by it. They were complaining that they weren't going to have time to have enough public hearings and enough public input on the whole process. But the court said, that's not what I'm asking you to do. I'm asking you to follow the guidelines of Prop 4, but you don't have to go through everything with the Independent Redistricting Commission. And so, as I said, their arguments, the legislature's arguments to the Supreme Court, mostly focused on this remedial process that the lower court put in place. But, and this is what the Supreme Court wrote, they have not appealed the order putting that process in place. Instead, they challenged the district court's denial of their motion to stay the court's injunction on the congressional map. However, their complaints about the remedial process do not demonstrate that the court's denial of the stay order is legally wrong or that the court otherwise abused its discretion. Without that, they have not shown why they should receive the extraordinary relief they seek here. So they were arguing things and wanted it both ways. They were complaining about the remedial process that they had agreed to go through, but they didn't offer any evidence to support their argument that the court erred in not granting the stay. So now they have to draw new maps. They have to go back to the drawing board. And as we are recording this, there's about 10 days before they have to submit these new maps to the court. And these maps, again, have to follow the guidelines of Prop 4. They can't use any partisan data to draw these maps. They can't draw them to favor an incumbent, a political party, or a candidate. They can't even consider where the incumbents live. Not that it matters on the congressional map. Burgess Owens doesn't really live in his district. Blake Moore doesn't really live in his district. So that's really not a problem here. Now, if they were drawing other maps, like legislative maps, yeah, it'd be a big problem. But right now, they just can't use any partisan data and can't draw them to favor one party over the other, or a candidate or an incumbent. This whole court case is about Prop 4. It's about the voter-approved initiative from 2018 that established an independent redistricting commission. And if you remember, what lawmakers did is they repealed Prop 4 in 2020, replacing the independent redistricting commission with one that had an advisory role rather than they got to draw the maps and the legislature had to vote them up or down. They flipped it around so that the legislature got to pick the map ultimately. The commission got to submit maps, and they went through this whole process, hearings all around the state, open hearings, fought about the maps, took submissions from the public. They submitted maps to the legislature, but the legislature did not have to take a vote on those maps. And what the judge ruled is that the legislature illegally repealed this government reform measure, and so that's why we're here today. I did some analysis work, and I hope you read my story, and if not, we're going to go over it here. It shows why the legislature doesn't want an independent commission drawing the maps, because there were 3 maps submitted to the legislature by the independent commission in 2021, and all 3 of those maps would have created at least one Democratic-leaning congressional district. And there's really no way to argue it when you look at the numbers. If you plug the 2024 election results, which I did at a precinct level, into all of the maps created by the independent commission, if you plug that into those maps, you found that Democrat Kamala Harris would have carried at least one of those districts on all 3 maps, and it wasn't even close. She would have carried it by a fairly wide margin, while Donald Trump would have carried the other 3. Other elections play out the same way. Look at what happened in 2022. There was no Democrat on the ballot, but Evan McMullin, the independent candidate, ran against Mike Lee for U.S. Senate, and there would have been at least one district that Mullen would have carried in 2022. So you could argue, and it's a pretty convincing argument, that Republicans cost Democrats a congressional seat through this repealing of Prop 4. So let's look at some of the numbers right here. As I said, during the 2021 process, the Independent Commission, they produced 3 separate congressional maps that followed Prop 4's requirements. 2 of the proposals, dubbed orange and purple, created a couple of really compact districts centered around Salt Lake County and Utah County. The 3rd proposal, which came from a member of the public, created more of a pinwheel shape that looks a lot similar to what lawmakers came up with, where they split Salt Lake County into 4 pieces. The Republican majority in the legislature ignored all 3 of those maps. They passed their own map that, as I said, splits Salt Lake County into 4 pieces. I talked about this on an earlier podcast. When you look at the numbers, they divided all of the Joe Biden voters, the Democratic voters from 2020, almost equally among the 4 districts. So that's how gerrymandered those maps were. And if you look at these maps that came from the Independent Commission, they were not gerrymandered because there was probably one seat that should have gone to a Democrat. Consider the orange map. It created the strongest Democratic district. One of the districts would have gone for Kamala Harris in 2022 by 22 points. Trump would have won the other 3 anywhere from 24 to 45 points. The purple map, Harris would have won one of the seats by 20 points. Trump would have won the other 3. The plan that came from the member of the public, it was dubbed SH2. The Democratic-leaning district there was 17 points. It would have gone for Harris for 17 points. in 2024. And let's take that out to the 2022 U.S. Senate race. Under the orange map, Evan McMullin would have carried the district that went for Harris by an even larger margin, 32 points. Under the purple map, McMullin would have won the Democratic-leaning district by 29 points. SH2, the member of the public map, that would have gone to McMullin by 26 points. I even plugged in older election results from the 2020 presidential and gubernatorial races, and the results held. The orange map would have had a district that would have gone for Joe Biden in 2020 by 24 points. The purple map would have a Biden plus 21 district. The SH2 map would have had a Biden plus 29 district. And the gubernatorial race in 2020, that also would have given similar results, but it would have been a little tighter. Democrat Chris Peterson would have carried one of the 4 districts under each of these 3 independent maps against Spencer Cox in 2020. The orange map, one of the districts would have gone for Peterson by 7 points. The purple map, a Peterson district plus 4. SH2 map, Peterson would carry a district by 5 points. This shows you exactly why the legislature decided to repeal Prop 4. They did not want an independent commission drawing these maps because they would have resulted in a seat that had a very good chance of electing a Democrat. Obviously, candidates matter, candidate quality matters, incumbency matters. But if you look at this, it would have been very hard for a Republican to win those seats, or at least one of the Republicans we currently have in Congress who are very conservative. A moderate Republican might have had a shot, but that's not what the Utah Republican Party wants, or at least the Utah Republican delegates want. They don't want moderate candidates running, or they don't want to have to moderate themselves and pick someone who could win, because ideological purity is what matters for them. And that's why the current congressional setup is what they like, because they get these partisan warriors, these hardcore right-wing partisans in office, rather than picking someone who would be more to the center and would appeal to a larger swath of voters. You cannot look at this analysis and argue in any way, shape, or form that Democrats would not have had an advantage in at least one of the congressional districts on these maps that came from the Independent Commission. And that right there is the main reason that Republicans decided to repeal Prop 4 and replace it with this independent commission that was essentially toothless. One other story from the gerrymandering lawsuit. This was last week before the Utah Supreme Court denied their request for an emergency stay. Utah Republicans latched onto something in a court document and really thought that they had something, but it turns out it really was nothing. They thought they found something in one of the orders from the judge that created a lifeline that gave them a foothold, something that would invalidate the entire case. This all comes from a footnote in the scheduling order from Judge Diana Gibson that was released late last week. And in that footnote, she adjusted some of the language in her original ruling around what the legislature was required to do when she said that new maps were needed. She wrote, quote, "The court amends its ruling and order to remove the, quote, order requiring the legislature to design and enact a new congressional plan in the next 30 days. That order failed to recognize the separation of powers between our courts and our legislature, and unintentionally failed to respect the legislature's authority to determine how to address the court's order. The court overstepped its authority by ordering the legislature to enact a new congressional plan." So essentially what she did is she changed the language further up in the order and explain the change in this footnote. And instead of saying the legislature must draw new maps and submit them, the legislature may draw new maps. And she explained the change in language because she failed to recognize the separation of powers, because the court cannot order the legislature to do something, just like the legislature cannot order a court to do something. But what happened was Republicans pounced. And it just shows you how desperate they are for some sort of lifeline, how desperate they are to not have to draw new maps. They absolutely jumped all over this. They said that this footnote was smoking gun evidence of what they said were fundamental flaws in Gibson's entire ruling. They said it just showed she was trying to clean up a blunder she had made. This was a messy cleanup attempt. Senator Dan McKay said this was just an obvious mistake that makes you worry about her entire analysis in the case. And even Senator Mike Lee, who would not be affected by this in any way, shape, or form, he argued that it showed that the judge is, quote, replacing the will of elected lawmakers with her own policy preferences. So they were celebrating and thought that this was going to be enough to convince the Utah Supreme Court to keep the current maps in place. Well, no. As we talked about before, the Supreme Court said that the new maps have to go. They wouldn't stop the process. But if you look at where that footnote came from, this revision, this change in language that they said was proof of judicial incompetence, actually was suggested by lawyers for the plaintiff in the case. And if they had done the reading, which they clearly didn't, but if they had done the reading from a prior filing from the plaintiffs, they asked Gibson for this amendment to change that language because they wanted the language of her order to align more with Prop 4. What they said in their filing on August 29th, a couple of days before the scheduling order came out, they wrote, plaintiff suggests an additional clarification to the court's order. Proposition 4 provides that upon the issuance of a permanent injunction, the legislature may enact a new or alternative redistricting plan that abides by and conforms to the redistricting standards, procedures, and requirements of this chapter. That's what the plaintiffs wrote. And Gibson said, that's probably a good idea. So the change just makes it clear that lawmakers could draw new maps by the court-ordered deadline, which she moved to September 26th, but they didn't have to. But if they didn't, well, they were facing a choice, essentially. They either had to give new maps or run the risk that the court would use a different map. I spoke to an expert on this sort of thing with the Cato Institute, and he told me the judge was probably being very careful, treading around the separation of powers, but it's also kind of like disciplining a teenager. At some point, parents realize they can't make a teenager do anything, right? If you're trying to discipline a teenager, you can't make them do anything, but you have to put a consequence in if they don't. And that's what the judge was doing here. She said, you can draw new maps. You have every opportunity to draw new maps because the old maps are illegal. You can draw new maps. You don't have to, though. But if you don't, then you're running the risk that there's going to be something that happens. Isn't it Rush who said, even if you fail to choose, you have still made a choice? I hope I'm aggressively paraphrasing there, but that's what this is. The judge changed the language at the request of the plaintiffs to say, yeah, you don't have to draw these new maps. I can't order you to draw new maps. But if you don't, there are going to be some consequences or some things will happen that you may not like. Republicans, they were celebrating for a couple of days, thinking that they had figured this out, how they were going to be able to put this whole thing on hold and get the Supreme Court to halt the process and keep the old maps in place. Nope, sorry, didn't happen because the plaintiffs asked for this change. I'm not a lawyer, but I know you're supposed to do the reading, and I decided to ask some questions and try to figure out where this came from. And turns out it took me about 2 phone calls to find out that this came from the plaintiffs and it wasn't some big error by the judge. It pays to do the reading. So what's next? Well, for the legislature, the clock is ticking, and we'll see their new map proposal when it's submitted to the court on the 26th of September. The plaintiffs are going to submit their own map at the same time. I still think that what's going to happen is the legislature is going to submit a map that almost or kind of complies with Prop 4, but it doesn't completely comply with Prop 4. You're going to get a map that's still 4 Republican-leaning districts, and maybe you'll take one of the districts from a plus 14 Republican advantage down to a plus 6, plus 5, plus 7 Republican advantage. And even at that advantage, I mean, that's really going to create a semi-competitive district. And I really think that it's going to put one of our current members of Congress behind the 8 ball. People I've talked to said it's probably Burgess Owens who will get sacrificed or who will be put into that district. Because when you look at our current congressional delegation, who is the one who gets the short end of the stick? It's probably the 78-year-old member of Congress, not the younger ones, Blake Moore, Celeste Malloy, and Mike Kennedy. It's probably going to be Burgess Owens. And I don't know if he would try to run again in a district that would be much more Democratic. He really hasn't been raising a lot of money comparatively to what he's done in the past. I'm sure he will be able to find the funds to run, but it's going to be a scramble to get all of that in place. And if he doesn't run, what happens? It's going to set off a land rush on both sides. I think you'll see a bunch of Republicans try to get into the race, but you'll also see a bunch of Democrats looking at a competitive district. And remember, in Utah, when we have a primary election, it's not a majority. Somebody, if you have 6, 7 people get into the primary by collecting signatures, you need 7,000 signatures from voters, or you go through the convention, you get into the primary, it's entirely possible that someone wins that primary with less than 30% of the vote. But that's the rules. We don't have a runoff. We don't have a way of determining that the actual nominee is someone who is favored by the majority of the party, or even a large plurality of the party. You're going to have someone win with less than a majority unless somebody is far and away able to wrap up the nomination at convention and isn't challenged. And I don't think you're going to see that. I think the idea of a seat in Congress is just too tempting for a lot of politicians, and you're going to see a lot of the same names get involved and some new names. And there's some people who have been thinking about running for a long time. So this is going to set off a stampede of candidates in that scenario. And also, I think that if the legislature submits a map that doesn't quite meet Prop 4, and there are ways to draw these maps that have Republican majorities that meet the requirements of Prop 4, but you're not going to be able to make them as rock solid Republican as the current maps are. There's just no way to do that because the current map splits Salt Lake County into 4, and really the most you would be able to split Salt Lake County is in 2, and there's really no way to split that to I guess, water down the Democratic advantage that comes from a large part of Salt Lake County. There's just no way to do that. So if the judge does accept that map, then we'll see what happens. But if the judge says, no, you haven't met the conditions of Prop 4, that might start a new round of legal challenge. And I don't know if we're going to be able to have new maps in place by the 2026 election. I'm still not 100% convinced that we're going to get there. But if we do get a new map, I think the race for at least one of the districts is going to be very interesting to watch. I think the other districts are going to be non-competitive because of the overwhelming Republican advantage, but I'm pretty sure that we're going to have at least one competitive district or slightly or semi-competitive district, which is a lot different than what we've had here in Utah over the last few election cycles. That's going to do it for this episode. Thank you so much for listening. Before we go, do me a favor, subscribe to this podcast if you haven't already. Do it wherever you get your podcasts. Also, subscribe to my newsletter at utahpoliticalwatch.news. And if you feel like supporting my work, making more podcasts like this available, more of my reporting possible, then consider making a one-time donation or becoming a paid subscriber. You'll find the link to the tip jar in the show notes and also a link to where you can sign up for my newsletter. Once again, thank you for listening. We'll be back with another episode soon.